Greetings. Today is our first day on corporations. As you know, for the July bar, we will be tested on business associations along with corporations and other business associations such as partnership agencies and limited liability corporations. Those topics, the additional topics over and beyond the traditional corporation topics, will be covered on a separate video, which will be on the archives. We're in the process of making it now. The reason I haven't quite made it or finished it yet is that I'm trying to get as much input as I can from the State Bar as to what they expect you to know. And no one seems to have that yet. And I've looked at all the sources and talked to people at the law schools who are professors of this stuff. And we have our guesses as to what they're likely to test, the things that would make the most sense, what other jurisdictions test. And that's what's going to be on the video. But I'm delaying a little bit longer because the State Bar said they would give us some additional guidance on civil procedure and on evidence, and so I presume they'll give us some additional guidance on business associations also. In any event, the additional material is not real extensive, and I'll make sure that that is put onto a video, on a separate video on the archives, which you will have access to. And I'll be ready and need about 2 weeks to be sure we've gotten the best shot at it that we can in terms of what they're likely to test. Certainly that's plenty of time before the bar exam. That's the end of the announcements. We'll start class in about 30 seconds. Greetings. Today is our first class on corporations, and we will study the formation, the issues that come up during the formation of the corporation. We will also study some of the issues which come up during the existence of the corporation, such as the violations of the duty of care, duty of loyalty. We will not today study the securities 75 and 16B, those issues. We'll do those next week. So what we want to study today is formation of corporations and the breaches of duty of loyalty and duty of care during the existence of the corporation. Now, let me tell you something in general about corporation law that will be helpful. That is that corporation law is like a number of other areas on the bar exam, where what the area of law does is to regulate relationships between people. For example, if you and I have a contract, then the law of contracts regulates our relationship. If I am a trustee and you are the beneficiary, then the law of trust regulates our relationship. If I if I write a will and you are the beneficiary of the will, the law of wills regulates that relationship. In the case of a corporation, it's one of those numerous areas of law where the regulation is about the relationship between people. And in all of these areas, the basic strategy for analyzing a problem in these areas is, number one, did the parties create the relationship regarding that this area of law regulates? Did the parties really create a contract? For example, and there's a whole body of law about formation of contracts. Did the parties really create a trust? Did they really create a will? And you have to look to see if this happened before you can go on to analyze their duties under the contract, or what should be done with the terms of the will, the trust. In the same way is with corporation law, in that step one in corporation law is, did the parties create a corporation? And so we need some rules about what it takes to create the corporation, or not just what it takes to create it, but the kinds of things that go wrong in the course of creating the corporation, and what do you do about those things? For example, in the course of creating a corporation, what do you do if the promoters form a contract, and they form a contract, but and they say in the contract, I am contracting on behalf of the corporation to be formed. The corporation doesn't exist yet. What do you do if the promoters borrow money on behalf of the corporation to be formed? What do you do if the corporation if the promoters buy goods on time, on credit? What do you do if the promoters go out and lease some office space? All this happens before the corporation is formed, and then the corporation is formed. Is the corporation bound, or what happens in those cases? And so those kinds of things, as well as what do you have to do to create the corporation? That's not tested very much. It's not that big a deal to create the corporation. So step one in corporate law is, what do you have to do to create the corporation, and what do you do about these little problems that may occur along the way of creating the corporation? Once you have created the corporation, the next problem is what in all these areas of law, in the case of the trust, corporation, contract, once you've created the relationship, what are the rules that regulate the relationship between the parties in this type of a relationship? For example, what is the rule in the case of contract law? If you and I have a contract, what do I have to do, and what do you have to do, and what are the things I cannot do? If we have a trust, what is the trustee? What are the trustee's duties, and what are the trustee's obligations? And so to the beneficiary of the trust, what are the beneficiary's duties and obligations, if any? And likewise for various other kinds of areas of law where people have a recognized legal relationship, trust, contract, will, corporation, agency, partnership. When people have these kinds of legally recognized relationships, what are the rules about what they can and cannot do? In other words, what are the duties for in each relationship and each of the parties to this relationship? What are their duties and what are their rights? Is what we want to know. And what remedy is available if a person breaches a duty? What can you do about it? So you want to know the rights, duties, and remedies of each of the parties in the relationship. And that same applies to corporation law. In corporation law, there are three parties to the transaction. In the case of a contract, you really only have to have two parties. In the case of a trust, you need three people. Somebody is a settlor who creates the trust. Somebody else is the trustee who's got the property, and someone else is the beneficiary. So there's three people involved in that. Now, if you come to the case of a corporation, this is a three-party type relationship. For one thing, you need the officers of the corporation, the directors of the corporation, and the shareholders of the corporation. Obviously, you can have more than one person to fit each of those categories, but you need three categories of people. Likewise, in the case of a trust, you can have more than one trustee. You can have more than one beneficiary. But we're talking about the office rather than how many people are in it right now. So in the case of the corporation, there are three people. There are the directors of the corporation who set policy. There are the officers of the corporation who run the day-to-day activities. They hire people, they get, they cause things to happen, They pay the rent, etc. They keep book, all the regular day-to-day things that you do in running a business. So the board of directors set policy, the officers manage the day-to-day activities of the corporation, and finally the shareholders are the people who own the corporation. And the dividends get paid to them, and certain things you need their approval for, and so forth. So in this case, in the case of the corporation, the three office positions are shareholders, officers, and directors. And what we want to know in corporate law is, how do you get to be each one of these? How do you get to be a director? How do you get to be a shareholder? How do you get to be an officer? And once you're in that position, what are your rights? What are your duties? And what remedies are available to you if someone violates a duty, or breaches a duty? Rights, remedies, and duties, and how do you get there? And also, how do you terminate it? If you get to, if there's one, you get to be a director, how do you get removed? You get to be an officer, how does that come to an end? You get to be a shareholder, how does that come to an end? So you want to know how to get to be one of those people, how to terminate that, and when you have that relationship where you're one of those three people, what are your rights and duties and remedies in that relationship? And that's what we will be studying. We all know certain basics that I will review for you in about 1 minute. The basics are that in the case of that the shareholders are the people who own shares of the, first of all, a corporation is an artificial entity, it's an artificial person, not a real person, it's an artificial person, and it can do a lot of the things that real people can do, in the sense that this artificial entity called a corporation can own property, it can buy and sell property, it can sue in its own name, it can be sued, and this is not the only artificial entity that can do that. A trust is an artificial entity. And the trust can own property, it can sue and be sued. The trustee is the person who manages the trust, and trust has beneficiaries and so forth. So as to the corporation, the shareholders are the people who, the corporation is an artificial entity, and people own shares in the corporation. And once, if you are the, when you look at all the shares of the corporation that are out there owned by people, people own the shares, and that is the entire ownership of the corporation, the people who own the shares. So those are the shareholders, but the shareholders don't necessarily operate the corporation. The shareholders have a right to vote on who they want to be directors of the corporation. These directors set policy. So once a year, annually, the shareholder, you must have a shareholders meeting, and at the shareholders meeting, the shareholders can vote to decide who they want to be their directors. And then once you have directors, the directors must meet from time to time, and at these meetings, the directors will set policy. The directors will, first of all, themselves elect, the directors will elect the officers. Officers such as the president of the corporation, the secretary, that's the person who keeps the records of what the corporation does and should do. President, secretary, and the treasurer, of course, keeps track of the money. So the corporation must have a president, secretary, and treasurer. It doesn't have to have vice presidents and vice this and the other and so forth, but it must have those three categories of people, just like a trust needs a settlor, a trustee, and a beneficiary. A corporation needs to have at least three officers, and the president, secretary, and treasurer. And these are elected by the board of directors. Now, and they obviously do the jobs that those titles suggest that they do. So we know now, how do you get to be a shareholder? Answer, if there is a corporation, we're talking about creating the corporation in just a minute. But if you have a corporation, the way you get to be a shareholder is you buy some shares. You give the corporation money and you get back the share certificates. So that's how you get to be a shareholder. How do you get to be a director? You get elected at the annual meetings to be a director. Certain special cases, of course, where a director leaves office during the middle of the year, the people who you can either the people who are left in office usually have the power to replace that person. How do you get to be a director? You get elected. How do you get to be an officer? Well, the board of directors elects the officers. Now, once you're in these offices, what are your duties? And in summary, the directors, the board of directors, set policy of the corporation, but these policies are set within the guidelines of the articles. When the corporation was created, it was created as an artificial entity to be recognized by the state, and this artificial entity that's recognized by the state has in its creation document is like a constitution, like a government has a constitution, and it says what the government can do and can't do. Well, the articles of the corporation are kind of similar in that they set, the broad standards of this is a corporation that is going to engage in the insurance business, or maybe we're going to engage in the banking business, or we're going to engage in the teaching business, and or whatever kind of activity you want. You used to have to identify the type of activity that your corporation is going to engage in, but now almost all states have loosened up on that a lot. You can say in your articles that this corporation is authorized by its articles to engage in any lawful business. So the articles of incorporation are kind of like the Constitution, and they say what kinds of activities your corporation can engage in and things they maybe can't do. The articles will also say how many members there will be of the board of directors. Might also say how many kinds of stock you're going to issue, ordinary common stock, are you going to have some preferred stock or not. The articles will also say how many shares of stock you're going to issue. If people give you money, you give them shares of stock. How many shares of stock are you going to issue? That sort of thing is in the articles of incorporation. And the policies which are set by the board of directors must conform to those articles. If you want to change the articles, then the board of directors get to vote on it, and the shareholders also will get to vote on that. Finally, just as you can have a constitution for a country, and the Constitution sets these broad standards, that you now have specific statutes in a typical country, and these statutes are much more specific things that regulate the country. And likewise, in the case of the corporation, the board of directors can create bylaws, like subcategories of the articles, so to speak. And these bylaws will have specific things about how they're going to do one thing or another that's much more specific, too specific to be in the broad articles. So we have a board of directors, we have a set of articles, we have a set of bylaws, and then finally comes the officers and directors, and the officers are to act in good faith to carry out whatever duties the board of directors says they should carry out. So that's basically how a corporation is structured. And what we want to look at now are the kinds of things, first, the kinds of things that go wrong when you are creating the corporation, and what can you do about it, in particular the ones that get tested. Well, first of all, to create a corporation, you typically need someone who is the promoter, who's going to go do it. This person usually has some new idea, and they want to have a manufacturing company to make this new gadget, or they have this person wants to open an insurance company, and so they're going to start it. So the idea doesn't have to be brand new in the sense that no one else has done it before, but they basically want to put this group of people together for the purpose of carrying out this activity. You can do it for the purpose of having a group that's going to buy and sell real estate, for example. Most of the buildings, the major buildings that you see, are owned by corporations, not by an individual. So if a person is a promoter, and this promoter wants to create a corporation, what does the promoter do? Well, the promoter needs to find some other people who want to put up some money. And so let's say you found 10 people. Each person says, I'll put up $10,000. And so the promoter has now found 10 people who will put up $10,000 each. they are willing to buy this stock from the corporation when the corporation is formed. The corporation hasn't been formed yet. The promoter just went out and talked up the idea and found these 10 people, each of whom is willing to invest $10,000. So we have a promoter who's doing all this, and we have some potential investors. And what typically happens next then is that the promoter will form with these investors what is called a pre-incorporation subscription agreement. Be sure that's a lot of words there to put this on the board. A pre-incorporation subscription agreement. This pre-incorporation subscription agreement is something that the promoter will present to the prospective investors, and they will usually sign this agreement. And what the agreement says is that when you create the corporation, I will buy 10,000 shares at $1 a share. And so each person signs this, each of the 10 people that the promoter has found, or however many they are, would sign this pre-incorporation subscription agreement, offering to buy. Now, the subscription agreement is not a contract between the promoter and the investors. Okay, it's not a contract. It is instead simply an offer. It's a continuing offer by the investors that when you create the corporation, I hereby offer. And my offer, if it's a promoter, let me be the promoter to make this clear. I'm the promoter, and there are some people out there who want to invest. What these people, person number one, says to me is that when you have created the corporation, I hereby offer to buy. The offer that the investors are making are to the offers are to the corporation. Okay? The offers to the corporation, not to the not to me, the promoter. They're making their offer to the corporation to buy some stock from the corporation when it is formed. So the promoters make an offer to the non-existing corporation that it will buy the stock when the corporation is formed. Now that's an offer. It's an ordinary contract, and it's a continuing offer. When the corporation is formed, now the corporation has got a board of directors. It can now vote. Shall we accept this continuing offer from the from this prospective investor? And if the corporation votes and says yes, we will accept, now you have a contract between the corporation and the prospective investor. Okay, I'm the promoter, but I was never a party to this contract. I mean, I got the people, I located the investors, and I got them to make the offer. But the point I'm trying to make here, and stumbling a bit, is that the offer is to the corporation. It's not to me, the promoter. The offer is to the corporation. And when the corporation is formed, it can decide that it wants to accept the offers, in which case now there's a contract between the prospective investor and the corporation. And now the corporation, now they perform the contract, the investor gives the corporation the money, and the corporation gives them some shares. So that's how you normally raise money for the corporation. That money that the corporation gets from the investor goes into an account that is called the capital account of the corporation. So in my case, where I have 10 people, each of whom is willing to buy $10,000 worth of stock, they give the corporation the $10,000. Corporation gives them shares. That $10,000 goes into an account at the corporation called a capital account. And when all 10 people have put their money in, the capital account will now have $100,000 in it. And that's the capital account. Historically, just to divert for just a second, historically what would happen is that the corporation would then start spending, doing whatever its project is, spending money from the capital account. And they would spend money, and as they spent the money from the capital account, presumably whatever they're doing is going to make money sooner or later, and when that money begins to come in, that money also goes to the capital account. And let's suppose that the corporation spent down to $60,000. They started with $100,000. They spent down to $60,000. Now they've got $60,000 left in the capital account. At this point, whatever the corporation is doing is beginning to pay off. The capital account begins to build up again, $65,000, back up to $70,000. Traditionally, the corporation could not pay dividends to the shareholders until the capital account was built back up to the $100,000. Then any money in the capital account over and above the $100,000, the corporation could pay out as dividends. But they could not pay any dividends until the capital account was built back up to the original stated amount. When the capital account is below the $100,000 in my case, we say that the capital account is impaired. And historically, corporations could not pay dividends from the impaired capital account. They have to wait until it has been built back up to the original stated sum, and then you can pay after that. Now, there are all kinds of rules nowadays that you're expected to know about that allows the corporation to pay dividends even when the capital account has not been fully repaired. You can pay nimble dividends, and there's you can even pay dividends even when the account has gone down, the capital account has gone down to $60,000. And you want the shareholders to feel good about it, because right now they're getting nothing. It's watching their money go away. So you can even pay, nowadays, you can pay some dividends out of that $60,000. But you can see that that's not earned money. You're just giving the investors back some of their own money. So you have to identify this as their own money when you're giving it back, because they don't have to pay taxes on that. This isn't earned income. But there are lots of rules now that will sometimes allow you to pay dividends out of, even though the capital account is impaired, and we will talk about those. But we're just trying to get the general ideas across right now. Normally, in order to pay dividends, you need surplus. You need either earned surplus, because the money was earned and it's earned surplus, or you can have paid-in surplus. Paid-in surplus occurs if I normally sell my stock at $10 a share, par value. Let's say it had a par value of $10. If I've done so well that I can get people to pay $12 for the par stock instead of $10, I've got a $2 surplus in there, and I can actually pay dividends out of that $2 surplus. That's a paid-in surplus. Earned surplus, of course, is profits that people have made. Nimble dividends are when you're paying it, you really haven't repaired the capital account. So those basic ideas are there. So now we understand how the corporation gets formed. We understand how money comes in. We understand that typically there's this pre-incorporation subscription agreement between me, the promoter, if you make me the promoter now, and you, the shareholder. And we want to get back to this formation process. I just wanted to connect it up as I did just a minute ago. But I want to get back to this formation process because there's things in there that are frequently tested. In the case where I am the promoter and you are the potential investor, and we enter into this pre-incorporation subscription agreement, there are some problems that come out of that. One of the problems is that, let's suppose that you sign this pre-incorporation subscription agreement, and in the agreement you say something like, I offer to buy 10,000 shares of the so-and-so stock at $1 per share. And you sign it. Yeah, this is a pre-incorporation subscription agreement. Now let's suppose that you've made this agreement with me and I'm the promoter, and now the corporation gets formed, and we haven't talked yet about how to form it. We have to do these one thing at a time. So now the corporation gets formed, and the corporation, the directors, the board of directors has a meeting, and the board says, yes, we accept this offer along with the other offers, and you now have a contract with the corporation. They let you know this, and so they ask you, please pay up and we'll send you the stock. Now it turns out that you don't want to do this anymore. Okay, you don't want to buy into this corporation. You may have your reasons, but whatever they are, the question is that you now have a contract with the corporation. Is it enforceable? Can the corporation make you buy even though you may have changed your mind? And the answer is yes, this is an enforceable contract which they can enforce, subject to 3 defenses. And it has the usual contract defenses, fraud, statute of frauds, undue, unconscionability, mistake, all the normal. This is a contract. They got all the usual contract defenses. But assuming that the contract is otherwise good, so you don't have any of the normal fraud, duress, unconscionability, lack of capacity, mistake, you don't have any of that stuff. These are just, and so now we're looking for special defenses which apply only in corporation cases, not the general contract cases. And there are 3 of these defenses that you might assert if you don't want to buy. And these defenses are, let me put them over here because I have more space. And the 3 defenses that you might offer to try to not have this enforced is, number 1, that there has been a material change in purpose of the corporation after you signed this pre-incorporation subscription agreement. I told you that we're going to mine for gold. That's what we're going to do with this corporation. And after the corporation is formed, you find out that that's not really what we're going to do. What we're really going to do is to open a radio station. And you say, I don't want to be in that business. And so there's been a material change in purpose. And if there's been a material change in purpose, you don't have to buy. That's a good defense. Second defense that you can offer is that the corporation was not fully subscribed. When I say fully subscribed, suppose when I came to you to sell you the stock, I said to you, look, I'm going to sell 100,000 of these shares. Would you like to buy some? And you say, yeah, you'd like to buy 10,000 shares. And so what you expect, since I told you I'm going to buy 100,000 shares, is that you expect altogether that the capital account is going to have $100,000 in it before we start. And so you think there's going to be enough money for the corporation to succeed in carrying out whatever its business plan is. But now suppose I only sold 50,000 shares. I was unable to sell the full 100,000 shares. Well, if I can only sell, if I only sold 50,000 shares, let me take the extreme case so the point is very clear. Let's suppose I only sold 1,000 shares. And I sold them to you. You're going to buy, you say, you give me $1,000, you get 1,000 shares, and now you don't expect me to go into business until I've got 100,000 shares sold. But I never found anyone who would buy the rest of it. And so I opened business anyway with your $1,000. Well, your $1,000, of course, is going to go through the place like a sieve. And so you should not be required to put up your $1,000 if I haven't found buyers for the rest of the stock. And then we say if the stock is not fully subscribed, then you do not have to buy your stock. Now, how many shares is fully subscribed? Well, if I told you I'm going to sell 100,000, that oral statement is probably enforceable, but more commonly on the bar exam, if the 100,000 appears any place in the subscription agreement, for example, I offer to buy 100,000 shares, and now we say, let me change this a little bit. So you say, I offer to buy 100,000 shares, you offer to buy 10,000 shares. Sorry about that. You offer to buy 10,000 shares of the 100,000 shares of the X corporation, okay, to be formed. So you've offered to buy 10,000 shares of the 100,000 shares. Now this does not expressly say that I am going to sell 100,000 shares altogether, but the rule is that if 100,000 is, or whatever my total number is mentioned any place on this subscription agreement, that will be taken as my telling you that I'm not going in business until all 100,000 shares have been subscribed to. And so the stock is not fully subscribed until I got 100,000 shares committed. And if I don't have 100,000 shares committed, the stock is not fully subscribed, and you don't have to buy. And so that's your second defense. So not fully subscribed. So that's the second defense. The third defense that you can offer, that you don't have to buy the stock even though you signed the contract, is that the corporation is not a de jure corporation. Not a de jure corporation. And you know about the de jure, de facto, and corporation by estoppel. You probably remember that the de jure corporation is one where the parties have fully complied or substantially complied, not necessarily perfectly, but substantially complied with all of the mandatory requirements to create a corporation. Substantially complied with all of the mandatory requirements to create a corporation. Okay, that's then you have a de jure corporation. The other type you can have, as you must know, is de facto. There are three types here. The de facto and by estoppel. If a de facto corporation is one where, and this gets tested a lot, so it's really important that it's clear to you what a de facto corporation is. A de facto corporation, of course, is one where something went wrong. And now remember, for the de jure corporation, you don't have to have perfect compliance, but substantial compliance with all of the important requirements, the material requirements. You have to have that. And but in the case of the de facto corporation, let me give you an example, and then I'll give you the rule. There's a real example where two people wanted to incorporate, or actually several of them, wanted to incorporate. They went to a lawyer, and the lawyer drew up all the incorporation papers just like they were supposed to be and all that sort of thing. And then the lawyer says, okay, everything is done. I'll file these papers and you're incorporated. Have a good business. Well, the lawyer never sent in the papers, so they were never filed with the Secretary of State. And so these people really never became a de jure corporation, because filing the articles with the Secretary of State is one of the material requirements. And so when things went wrong and these people got sued, they thought that they were an incorporation and they were incorporated, and that the person suing them, could only reach the assets of the corporation, but could not reach their personal assets. However, they soon learned that the lawyer had not sent in the articles of incorporation, and since the lawyer had not sent in the articles, they were not a corporation. When this case got litigated, the court says, even though this was not a de jure corporation, it was a de facto corporation. It was a de facto corporation. What does it take to form a de facto corporation? And the answer is that a de facto corporation has three requirements: 1, 2, and 3. The first requirement for a de facto corporation is that there was a statute under which you could have formed a de jure corporation. If you're forming a corporation to make electronic parts or something, certainly the statute would allow you to form a corporation for that purpose. If you're forming a corporation to sell heroin, probably not. But so you need, first of all, a statute under which they could have formed a de jure corporation. Second requirement, that's the first requirement. Second requirement is that the parties made a good faith effort to comply. Good faith effort to comply. Good faith effort, and in the case of our people who went to the lawyer, drew up the articles, thought it was all done, thought the lawyer was going to send them in, never sent them in, those people made a good faith effort to comply. Sometimes this good faith effort is referred to as a colorable effort to comply. And they did that in our case. So a statute under which they could have formed a corporation, a good faith effort to comply, and finally, you need to use some of the corporate powers. You need to do something with it. You need to operate a business under the name of the corporation. Start sell stock. Issuing stock for money is exercising some of the corporate powers. Basically, just start business or start selling stock. That's what is required. So if your defense to putting up your money once you have formed the pre-incorporation subscription agreement, corporation is formed, the board of directors votes, they say, yes, we want your money. And now, if they want to enforce the contract against you, what defenses do you have left? And we know now that the defenses you have left are, one, if there's been a material change in the purpose of the corporation, you don't have to do it. This material change would typically show up in the articles of incorporation. Secondly, you don't have to buy if it wasn't fully subscribed. Thirdly, you don't have to buy if it's not a de jure corporation. If it's a mere de facto corporation, you don't have to buy. And finally, the corporation by estoppel. This is the case where in the corporation by estoppel, what has happened is that if you represent to people that you are a corporation, you may later be estopped to deny that. And likewise, if you represent to me that you are a corporation, and I believe you're a corporation, I do business with you, I even loan you money, use your corporate credit, and now I later find out that, oops, you're not a corporation after all. I thought you were, but there's some technicality as to why you're really not a corporation. Now, I technically should be able to go after your personal assets because you were not incorporated. And the court has said no to me. It says that would be a windfall for me. But I never expected, I did not do business with your corporation expecting to be able to reach your individual assets. And since I didn't expect that, they're not going to let me have it. And if your corporation goes bankrupt, that's all I get to do is to sue the corporation. So the corporation by estoppel, and So so we're back to the stage then where the promoter forms a pre-incorporation subscription agreement. People sign it. When it comes time to enforce them, these people have these three defenses that we just talked about. Now, so one of the things that goes on during this formation period is forming these agreements. A second thing that goes on during this formation period, besides forming these agreements to raise money, besides you do this to raise money, you form these are not contracts, these are offers, but you get these offers in order to raise money. But the promoters also often do enter into real contracts with people in the interest of the corporation. For example, the promoter might say, gee, this is a corporation that's going to engage in the practice of law, and we need office space. And so before the corporation is formed, the promoter goes out and finds a landlord and enters into a lease with a landlord for the space that the corporation is going to use to practice law. So they go out and enter into this contract, but the corporation really doesn't exist yet. And so if the corporation doesn't exist yet, and the promoter goes out and forms a contract, says a landlord says, I hereby lease to the ABC Corporation the use of this space for the next 5 years at so many dollars. And that's what the promoter has done. Well, the landlord's saying, I hereby lease to the corporation. Well, there is no corporation. It's still being formed. And in fact, the writing might even say, I hereby lease to this corporation to be formed. It doesn't exist yet. The agreement says, I hereby lease to the ABC Corporation to be formed the use of this space for so much money. Now, and so you now have the promoter forming contracts on behalf of the corporation when it didn't even exist yet. And so what happens in that case? Suppose several things can happen. The corporation may never come into existence. It may come into existence and not adopt the contract. It may come into existence and adopt the contract, the lease. It may come into existence, and this was a 5-year lease, and the corporation may last for a year and then go out of business, and there's 4 more years of rent. Can the landlord get that missing 4 years of rent from the promoter? Because after all, the corporation did not exist at the time the lease was formed. So what do you do about those? And that's the next thing we want to deal with then, are these situations where the promoter enters into contracts supposedly on behalf of the corporation when the corporation does not exist. What is the promoter liable? And can you get him unliable? What do you do? Well, the answer is fairly straightforward. That is, it really is going to turn on the intent of the parties. So the lease says I lease to the X corporation to be formed, and now it's signed by the promoter, or it might even be signed, sometimes it's signed by the person who's going to be the president, let's say, of the corporation. Let's suppose it. So the person might sign it without any name there. They might sign it this way, president. So now what we want to know is several things. when this happens, is the promoter liable? Is the corporation liable? If the promoter ever became liable, can you get him unliable? And what is the rule for deciding this liability? This is a very, very commonly tested area of law, and we will deal with this as soon as we come back from our break at 10 minutes after.